Welcome. Welcome, everyone. Good morning.
Morning,
welcome
my
to Frequency Radio. I'm your host, Yusef. My co-host, Paul David Savage. What's up, brother?
Morning, bro. How are you?
All right, good. It is Friday, March 1st, 2013. We come to you every morning, 8 a.m. to 11 a.m. Pacific Standard Time. Giving you what the others want and saying what the others don't. Got a good show for you today. Seems like my most popular show to date was a show I did last Friday on commercial liens. It was very, I was just surprised at how many people tuned into that show. I don't even remember what I said. Do you remember what I said?
No, bro, I was on the road. I haven't had to go back and check it out.
I know, I go back and listen to it. I'm like, what did I say on this show?
Yes.
We got some news this morning to a couple of things. And I've been following this thing about the Pope. And, I was following, and it seems like there might be some credence to, this Pope losing his position over there. It's, I'm just tripping on that. I was kind of looking at some information last night on that.
Yeah, it's some way powerful stuff, man.
Yeah, it is. Well, today we're going to talk about commercial liens. This is Commercial Liens 2. And the reason I decided, to do this, obviously everybody wants to know because people have problems out there and they, they like, okay, well, what do we do? You got these dishonorable public servants who won't do their job. Now, the first thing I want to say is that I'm not condoning putting liens on public officials and individuals like that haphazardly, because I think a lot of times most of these people are doing their job properly. I think more times than not, it is we, in our ignorance, who are bringing these problems upon us. And another thing is you are always responsible for the things that happen in your life. I want to say what's up to Queen Mother 9, I see you. Majuzi Sawuj, I don't know if I pronounced that right. World Ruler, everybody else, the guests that are, everybody slowly coming into the chat room. Good morning. But that's what acceptance is all about, is that you created your problem, and you have to accept the fact that you created your problem, and a thing is unbound the way it is bound. So you're responsible for that. It's only in situations where you have done everything honorably to solve the issue. And, you got these individuals out here that just want to keep coming at you and keep coming at you. And it's what you have to do to them. You have to, they have decided to go to war with you. And you have all the power. Actually, it's very foolish for them to attempt to go to war with you because you got much more power than they have. An individual attempting to do that, in my opinion, is insulting your intelligence. There's nothing worse than an individual insults your intelligence because they're saying to you is they don't think that you are intelligent enough or knowledgeable enough to stop them and their encroachment into your particular life. We're going to get to that. And I'm sure some public servants out there listening, and be warned that if you do not do your job, we are going to take that job from you. You do not have any right to work in a public service job in a bonded position or a position of public trust, and you do not do your jobs honorably. There isn't any money. If you're coming to us looking for the collection of a debt, there is no money. Federal Reserve notes are not money. One thing I want to say also is, first of all, that you have to make sure to be able to file a lien against someone, you have to have a contract in place, all right? There has to be some type of contract. Now, there are two ways we can get out of our problem. I was doing some research last night, and you definitely want to get your nationality correct. You also want to put these people on notice. You also may want to consider expatriating yourself from the United States. There are ways of doing that, filing with the Hague, the International Court of Hague, and so forth, sending them notices, and getting yourself out of the system totally.
Let me cut in.
Go ahead.
We don't have to expatriate because we've already been excluded.
What do you mean by that?
That we cannot be part of the corporate United States. We don't have to expatriate from something we're excluded from.
Well, you know what? I understand what you're saying, and I agree with you totally. I think what people don't understand is one of the rules of the game is public and private do not mix. They are not attacking you, charging you, or any of those things. It is this corporate fictitious entity that you have been amalgamated to.
Right.
And what they're trying to do is they're trying to hold you as a trustee of that particular entity. And I don't think a lot of people notice that. I know that I see a lot of information on the Internet, people teaching various things, but what always seems to be absent is the fact that that is not you on that piece of paper. I posted a video yesterday. It was a very, very good video of an individual who had a confrontation with the police. It was on it's on my YouTube, and it gives a very good example of understanding your rights. This particular individual was carrying a gun out in the public, and the police stopped him, took his gun, started asking him for information, and all he kept doing is saying, excuse me, sir, what is it that I've done? You know, what crime am I suspected of having committed? Before I give you any information, you need to tell me the crime that I'm suspected of having committed. Well, we got a phone call saying there's somebody out here with a gun. Well, that's illegal activity. There's nothing illegal about that. What crime am I suspected of being committed? Or could you just give me your first name? No, because when you get calls like this, there's a police report filed, and you need a name to go on that report. So to protect myself, I'm not going to give you my name until you tell me what crime am I suspected of being committed. I have committed. Now, I've done that before myself. Even though the police officer went to my car and tried to check my license plate to try to find out what my name was that way. But he just basically, he had just stopped me because I was in a nice car, and, just basically we have a lot of drug deals going on in this area. We're in a nice area, too, and, I'm a black man in a nice car, so I got to be a drug dealer. Okay. I said, sir, I'm a businessman. Give me your name and contact your supervisor. Now, the supervisor, believe it or not, is always around, somewhere close. It's almost like they're all together, and every time I've asked to call the supervisor, he always seems to get there within about 5 minutes. So their supervisor's wandering around with them all the time. So ask them to call their supervisor and get their name, get their information, ask them for their business card.
Let me jump in there.
Back to what I was saying, you can expatriate.
Right,
go ahead.
Let me jump in there right quick. Do you know why the supervisor is always around?
I think because they scheming already. But now he's required to be around, isn't he?
Because when they interact with somebody who asks for a supervisor, it means that they have lost control of the situation. That individual on the scene no longer has authority at that situation. It also means that they have encountered someone with knowledge and understanding. So the supervisor hurry ups and gets there, because once you take away their authority at the situation, they usually get pissed and do something stupid. So he's rushing there to make sure they stay calm and to make sure that they haven't already gotten themselves in a situation of liability. Because until now, it wasn't understood except by learned people that when you ask for an officer's supervisor, he no longer has any authority in that situation. You've actually just taken away whatever authority he may have assumed he had. So
that's absolutely correct. You take away their authority. I've done that several times. It works every time. And I think also that the police are not trained. I had a friend of mine who was a police officer. He told me that this is in Clayton County out there in Georgia. He told me, he said when they were instructed to arrest people who asked them if they had a bond. You know, I'm like, what? You know, arrest them. And I just arrest them if they ask you for your bond, you know. I'm like, okay. You know, these people are tripping, you know. But all those things right there, they are gonna, and when things like that happen, this is why we're gonna do this show. Because you will have officers out there who act in ignorance, and let's not call them arrest. Every time you get arrested, it is a kidnapping. Every single time you get arrested, you are being kidnapped.
And any time you are interacted with unsolicited on your behalf, it is a detainment, constitutes an arrest, according to the Supreme Court.
That's correct. You ask them, what crime am I suspected of having committed? You find out this information, and you get this information from them. And when they don't provide it, you know, that is when you need a name. A name needs to go into a commercial registry. My friend and I, we were discussing this, and he was saying that, because, you know, I was thinking that all these people have committed treason. The penalty for treason, y'all all know what the penalty for treason is. But I thought a second about it. I'm like, well, no, they haven't committed treason because they're really not a government. These are de facto, these are corporations masquerading as government. All these courthouses are not real courthouses. I'm posting videos constantly on my Facebook page showing people who are going into court challenging these people time after time. Is really growing because people are starting to wake up and find out that these people are not the authority. All these ridiculous crimes that they are charging 70-80% of the people who are in jail are there on victimless crimes. Now, another thing that needs to be understood is we are under a military occupation. The United States has occupied. Whenever the United States conquers an area, you'll notice they'll always put a base there. Well, they've done the same thing in the United States. When they won the Civil War, they split the United States up into 12 districts. This is why you have all these districts. And these courts are sub-corporations of the United States. That's something that people need to understand. We are under a military occupation. But it's fictitious. It is fictitious. Now, the only way that you can file a lien on someone is that you need to have a contract. And to have a contract, there has to be some agreement. Now, agreement doesn't necessarily have to be express. It can be implied through silence. And that's how we're going to be utilizing this particular procedure. This is the power you have over them because these people cannot really respond to you properly. But the problem we've been having is actually enforcing it. But when you put these UCC1 liens on them, it does have an effect in their life. It has a major effect in their life. But you need to do this honorably, and you need to have documentation to support what you are doing. Now, a little bit about attorneys real quick. I want to talk about the attorneys. I found a good document on the Internet. I want to read it real quick. And then the name of the document is Hiding Behind the Bar. why attorneys are not lawyers. I want y'all to understand the difference between an attorney and a lawyer. They are not the same thing. They are not the same thing. And let me read this to you, because another problem that people are having out there is they're putting too much faith in attorneys. And I want you to know there is a difference between at law and in law. There's a reason attorneys call themselves attorneys at law. That is a legal term. At law means fictitious. In law is the real law. At law is corporation. In law is real living souls. So know that distinction. Well, let me read this to you real quick. It said, why attorneys are not lawyers. In the U.S., they're collectively called everything from attorney to lawyer to counselor. Are these terms truly equivalent, or has the identity of one been mistaken for another? What exactly is a licensed bar attorney? This credential accompanies every legal paper produced by attorneys along with a state bar license number. As we are about to show you, an attorney is not a lawyer, yet the average American improperly interchanges these words as if they represent the same occupation. And the average American attorney unduly accepts the honor to be called lawyer when he is not. In order to discern the difference and where we stand within the current court system, it's necessary to examine the British origins of our U.S. courts and the terminology that has been established from the beginning. It's important to understand the proper lawful definitions from the various titles we now give these court-related occupations. The legal profession in the U.S. is directly derived from the British system. Even the word bar is of British origin. Bar, a particular portion of a courtroom, named from the space enclosed by two bars or rails, one of which separated the judge's bench from the rest of the room. Okay, now let me tell y'all about that bar. When you go in those courtrooms, stop going past that bar. Talk behind the bar. They will try to get you to come across that bar. Maybe even a bailiff will come up and approach you. Hey, you don't come across the bar, you're not going to go on record, or threaten you or something like that. Simply stand your ground and sit there and say, I prefer to stand behind the bar. Because every time I've seen people go across that bar, even when you go across the bar saying that you're going to do so with full reservation of all your inalienable rights, always seems to be a problem. There's something about coming in the well of that courtroom that we need to stay out of. Sometimes they'll switch up judges on you and try to use a judge maybe a little bit more experienced, try to coerce you into going across that bar. Don't go across the bar. You can talk behind the bar. And if they come and try to use the incompetency exam, one of the things they like, the only thing they got right now is this colloquy. Or they want to hold a colloquy on you in court saying, oh, you're mentally incompetent and all these different things, or do you understand? A judge, you don't have to follow any of those orders. That's another attempt to get you under jurisdiction. Do not follow any orders of any judge until they have established that they have jurisdiction on the record. So let me continue. Now, this gives a definition of a barrister, and it goes on to give a definition of a turn. A turn means to turn, change, transform, deck out, turn over goods, services, allegiance to another, transfer, or assign. Now, the word a turn in feudal law, to turn or transfer homage and service from one lord to another. This is the act of feudatories, vassals or tenants, upon the alienation of the estate. And that's out of Webster's 1828 dictionary. Attornment, the act of feudatory, vassal or tenant by which he consents upon the alienation of an estate to receive a new lord or superior and transfers him his homage and service. Attornment, that's Webster's 1828 dictionary. Attornment, as a noun, the transfer of bailiff status, tenancy, or allegiance, service, etc., to another. So what they're doing with this attornment as an attorney is they're turning over property to someone else. putting you under the authority of another. That is what an attorney is. Someone who turns over something to someone else. Now, it's very clear that an attorney is not a lawyer. The lawyer is a learned counselor who advises. The ruling government appoints an attorney as one who transfers a tenant's rights, allegiance, and title to the landowner. A human being, let me go back, feudal tenancy. If you think you are a landowner in America, take a close look at the warranty deed or fee title to your land. You'll almost always find the words tenant or tenancy. The title or deed document establishes your right as a tenant, not that of a landowner, has been prepared for transfer by a licensed bar attorney. Just as it was carried out within the original English feudal system, we presume we had escaped from in 1776. Now, a human being is the tenant to a feudal superior. Now, there's another thing I want y'all to understand. The word human being does not mean what you think it means in law. Google this on the internet. Google human being, monster, and find out that the definition of a human being in law means a monster. And I've gotten into that in some other calls, where I talk about the different levels of man. Because in the scripture, you're called a god. Watch out for these terms. A feudal tenant is a legal person who pays rent or services of some sort for the use and occupation of another's land. And that's what they consider us as feudal tenancies. Now, let me talk about the bar real quick. BAR stands for British Accredited Registry. Now, during the middle 1600s, the Crown of England established a formal registry in London where barristers were ordered by the Crown to be accredited. The establishment of the first International Bar Association allowed barrister lawyers from all nations to be formally recognized and accredited by the only recognized accreditation society. From this, the acronym BAR was established, denoting informally the British Accredited Registry, whose members became a powerful and integral force within the International Bar Association. Although this has been denied repeatedly as to its existence, the acronym BAR stood for the British Barrister Lawyers, who were members of the larger IBA. I have documentation that also shows that the lawyers are admitting now that they work for a foreign entity, the Crown. When America was still a chartered group of British colonies under patent, established in what was formerly named the British Crown Territory of New England, the first British Accredited Registry, BAR, was established in Boston during 1761 to attempt to allow only accredited barrister lawyers access to the British courts of New England. This was the first attempt to control who could represent defendants in the court at or within the bar in America. Today, each corporate state in America has its own bar association. In other words, the Florida bar or the California bar that license government officer attorneys, not lawyers. This is why they need a license also, because they're going in conducting business. You always need a license to conduct business. That's what licenses are for. Whenever you hear that word license, you can always assume that it is some type of business activity. That's why you need a driver's license. Driver's license is for businesses. You're presumed to be conducting business. All right? That's why you have a truck driver, taxi driver, bus driver. The word driver is associated with doing business. And you're not driving, you are traveling. Now it goes on to say, in reality, the U.S. courts only allow their officer attorneys to freely enter within the bar while prohibiting those learned of the law lawyers to do so. Now, another thing, this is why you always make an appearance in court in your proper person. You never come in under pro se status. Pro se is short for prosecutor. They're going to treat you as you are a licensed attorney if you have a pro se status. Now, if you want to see the proper definition, now this is a good example of why we need different dictionaries. Because when you look up the word proper person, in a seventh or eighth or ninth edition of Black's Law, you're not going to get a very, very good definition of that word. You're not. They're going to give you some real terse BS type explanation. They really, really try to hide the definition of that word. They really do. They try to hide the definition of pro se. I mean, of in your proper person. So I'm going to read from the 4th edition of Black's Law, which is a very good, when you want to find out some of the words like that, that's definitely one of them that you want to know. That's the only way that you can properly challenge the jurisdiction of the court, is that you are in your proper person. Yeah, there it is. In one's own proper person, it is a rule in pleading that pleas to the jurisdiction of the court must be pled in propria persona, because if pleaded by an attorney, they admit the jurisdiction, as an attorney is an officer of the court, and he's presumed to plead after having obtained leave, which admits the jurisdiction. Now, you ain't going to find this in a 8th edition Black's Law, but it tells you right here that when you make an appearance or you challenging the jurisdiction of the court, you have to do so in your proper person. You can't come in as a pro se and then challenge jurisdiction. It has to be done in your proper person, and you cannot use an attorney. That's why I wanted to read that to you. You cannot use an attorney. If you use an attorney, you have just given up. You've given up authority over your body to these people. So, number one, that's why I'm reading this right now about attorneys. Attorneys are not lawyers. The word attorney and lawyer do not mean the same thing. An attorney and a lawyer are not the same thing. And maybe some attorneys out there listening, and I'm telling you right now, you are not a lawyer. You went to law school and learned procedural law, not law. You have to get out and study to hit the books like the rest of us. You don't deal with substantive issues. You deal with procedural issues. This is why you see a 90-something% conviction rate. Now, also what I wanted to do this morning, I wanted to give y'all some words that I want people to start looking up. I'm going to start doing that, too. One of the words, a legal word that I want people to start to look up is a word called voluntary ignorance. That is a legal word. And voluntary ignorance means willful obliviousness, an unknowing or unaware state resulting from the neglect to take reasonable steps to acquire important knowledge. So, voluntary ignorance means you have that's where they get ignorance of the law is no excuse. Now, another one is called stultify. I want y'all to pay very attention to this one because they're going to use this a lot on you. To make one out mentally incapacitated for the performance of an act. Stultification means they try to make you look stupid. They use that a lot. It's called stultify. So those are my 2 words for the day. I'm going to try to start giving some words every day for everybody to look up. And before I get off topic, let me take one more phone call, and then we're going to go right into doing the lien. I'm going to put everybody on mute, and we're going to go on to these liens. 401-2998, you're on High Frequency Radio.
Hey, Brother Joseph, how's it going? This is Sam.
Hey, what's going on, Sam? How you doing?
Very good, thank you. I'm glad you brought this subject up because the last time you and I spoke, I'm having a situation for upcoming month about child support that the state is bringing up against my ex-wife and I. The fact is that she and I are on good terms. We take care of our son together. We're still good friends, help each other out when we can. But somehow the state came in and says she's the plaintiff and I'm the defendant. But the paperwork they state is that they're the one that's bringing us in, and the two parents are the defendant. So they're just throwing everything around and confusing based on the paperwork-wise.
I mean, you know, you just file a demand to see. Okay, here's the thing. This is why this stuff is very difficult to learn, because like you heard me say that one of the things that you have to master when you do this type of stuff is fear.
Right.
One of the things that they really put on individuals is they always try to keep you in a state of fear, and the reason and coerce you into doing things. That's the only. If nobody has any authority over you and they trying to keep up the image that they do and keep making money off of you, because that's all this is a money-making activity for tax purposes, when they really don't have the authority to do it. You know, they got to figure out some kind of way of you know, getting you to go along with their scheme. They got to find some kind of way of getting you to go along with their scheme. So they'll use things and they'll say, like yesterday when I read about a belligerent claimant, that you have to test, but before you offer any paperwork, before you come testify or anything like that, you need to challenge these people's authority that they have over you. Now, one of my rules of the game is staying honored at all costs. Usually, and I haven't talked about this on a call before, about these GSA bonds, but usually you give them some type of bond and take over the case and tell them to get rid of the case. When they don't want to get rid of the case, that's when you go into this thing with this commercial lien, because, see, you have a lot of these public servants who, you know, they're used to doing what they want to do, and they take offense at someone coming along trying to assert that they are the master and they are the public servant. They don't like that, you know what I'm saying? They like to posture as if they have all the control and authority, and they don't have any control or authority or anything like that. Our government is for the people and by the people. In this country right here, the people are the authority, not these idiots. So we're not acting in that way.
Right. See, what I was trying to do is, when you and I talked last time, I was going to send a letter to this individual. His name is he's Chief Legal Counsel, Frank DiBiase. What I want to do is send him some questions for him to reply back, which is ask for his bond, his oath of office, his delegation of authority, because, like I said, it's just a piece of paper. I don't know who you are. Identify yourself. So I want
exactly, and you're going to see that they're going to want to refuse to do that. Now, this goes into what I'm talking about commercial liens. Okay, you have to understand that letters are contracts.
Right.
Let me say this again. Letters are contracts. When you submit a letter or some type of correspondence to another party, that is a contract, and you need to draw it up as such. You need to draw it up as such. So when you ask him for his delegation of authority and so forth, in your correspondence, you also need to state your refusal to provide this information can only be presumed that you are acting as an imposter.
Okay.
And any further correspondence is going to subject you to charges in the amount of, and then you pick some amount, make it a big amount.
Right, yep.
Make it a big amount. Make it $100 million. If somebody trying to restrict your liberty or harass you, make it. Always, my thing is always start with $100 million or something like that.
All right.
No, really. You know, these people, check these CAFA reports out. These people got money. They got crazy. They like to keep us. Another thing they like to do, they like to keep us in a state of mind of what is considered a lot of money.
Mm-hmm.
Like, you know, they keep us $100,000 is a lot of money, $500,000. That is not any money. That's chump change. That's pennies.
Yes.
Pennies. That's literally, those are pennies. So, to get their attention, you need to make, the amount substantial. And you need to be sure that when you send it to them, you send it with a notary. Now, let me talk about the notary for a second. The notary's only job is to mail things. You're not interested in, you're not doing a protest. That's not a protest, all right? A protest is when you're dealing with negotiable instruments. All you're looking for from the notary is a certificate of non-response. The notary's only job is to be a witness that information was mailed. That's it. That's it. That's all the notary is doing.
Okay. One last thing. I have a notary that I use that I can have them forward the information over to, because the idea is they send these letters to my ex-wife's house, and they address it to her and I, 2 individual envelopes, but they don't know where I live. In reality, I live in a different location within the same city, but they mailed it to her house with my letter and her letter. So when I send this letter to this individual man, DiBiase, should I have it sent to? I know I'm going to be sending to the notary, but have it delivered to the notary, and when the notary receives it, you
make it very clear. Okay, your notary should have a P.O. box or some type of address. They always should have that. And you have to make sure that you make it very clear that all correspondence should be directed to this particular address.
Right.
You make that clear in your correspondence. They will try to ignore it and try to still send it to your other addresses. That right there is a violation, and that's when you go into this lien process. You begin to bill them. Okay. You send them a bill. Every time they do something. Once you get your letter and you say, okay, I just told you to do X, Y, and Z, and you didn't do it, and I told you it's going to be $100 million, you send them a bill for $100 million and tell them to pay it. And you send it to them for 3 months in a row. You send them a bill. You don't play with these people. You let them know. Because what this is doing, their silence or acquiescence in law is a staple in law. As long as you got evidence that they have been silent, now you have grounds to file a lien against these people. Now you have grounds where you can actually create a commercial affidavit. Now you have a contract. Okay. In a book, Cracking the Code, is real nice. They actually write their letters, and I do this too. I write my letters to them in the form of a security deed. In other words, here's a security deed. Here's what you're going to agree to if you do not provide me this, since you have a duty to respond. Now, here's the thing. If somebody is corresponding with you, they have a duty to respond. And responding has to be in a particular type of way. Like if you tell them, hey, very clearly in your correspondence that all correspondence needs to be sent to this address, and they don't do that, then they have not responded.
True, very true, yes.
Another thing that they like to do is they like to use Federal Express and UPS because they try to avoid mail fraud by using private carriers. And they don't like to put stamps on any of their documentation. Always, when you send your documents to them, you always use stamps. Do not use those red meter stamps. You always mail everything when you're dealing with these people with postage stamps. And you bill them. You send them a bill for 90 days. Now, when you file your UCC-1, because now you can put a UCC-1, get their barcode number if it's an attorney, or get the EIN number if it's a business. You're going to have to hunt that down. Like, for instance, the state of Rhode Island, they have an EIN number. They also have a Duns and Bradstreet number. These are businesses. These are corporations. It ain't no real country. They are for-profit corporation. They got an EIN number, tax number, all that stuff. Hunt it down. They got it. And when you file your lien, what you're going to have with that is you're going to have an affidavit associated with it. And you're going to have as exhibits, you're going to have all your correspondence. So what are going to be your exhibits? When you do a certificate of non-response, let me back up because I want to make sure everybody understands what I'm saying very clearly. You're going to send a correspondence, and it's going to be in the form of a contract. It's a letter, but really what it is, it's a security deed. You're going to, and in that particular correspondence, you are going to outline what your fees are going to be for refusal to provide necessary information. All public servants have to identify themselves. That goes for investigators, anybody who comes into your presence. Before you speak with them, talk with them, give them any information or anything like that, they need to identify themselves. And just because they have on a uniform does not identify themselves, because they could be masquerading or impersonating an officer or something like that. So I need bond information, I need badge information, I need information from this individual that can be checked out. Refusal to provide that information, you need to be prepared to bill them. You need to be prepared to bill them. All right, now when you bill them, you're going to send a statement of account, just like anybody else. You do exactly what they do. If you really want to see how to do things, you should really watch the IRS. The IRS will teach you a lot. They'll teach you a whole lot. They're the masters of doing administrative processes. Now, when you file the UCC-1 and you put, now what does this UCC-1 do? Well, one of the things is it messes up their credit, especially if you get, get it in their personal capacity. And you can do this because if they are not discharging a debt, you got to understand that everything that they are doing is a debt collection. If they don't satisfy the debt, then they're acting outside the ambit of delegated authority. They're trying to do some personal things. They're trying to put you in a state of slavery. And involuntary servitude is not permitted in the United States. That's why the coercion. That's why the coercive techniques. Now, you also, what you're going to do after you bill them, you're going to give them a notice of lien. You're going to let them know that they're going to be liened. You do all the same things that they do to us. Then you do a notice of proposed deposition of collateral. What you let them know is that you're going to start taking their property. Now, I'm going through this, and actually I want people to read documents on commercial liens. One of them, a good one on the internet, like I always says, commercial liens is the most potent weapon. But you're going to need, anytime there is a debt, there has to be a verification of the debt. So you need to have an affidavit. Step by step, what happened? You go, you say, like I'll read y'all a little bit of mine. What I always like to do, I always like to start my affidavits out, basically stating who I am. The affiant is a real living soul living under the laws of the creator of the boundless universe, sui juris. I'll say something like that, and I have firsthand knowledge of everything. I'm more than confident to make this affidavit. In your various states, you should look up affidavit in the code, and it will tell you a lot of times what is acceptable for an affidavit, what verbiage needs to be in your affidavit. And your affidavit needs to be numbered line by line. A lot of times I see affidavits out there, and they aren't numbered. They just have an affidavit, and it's just a paragraph or something like that. And you have to remember, sometimes y'all are following these attorneys and trying to imitate. A lot of them don't know what they're doing. Or they were doing half-ass work. An affidavit has to be rebutted point by point. So your affidavit needs to be in a point-by-point type way. And an affidavit basically outlines what happened. Paragraph 1, on such and such and such a date, I, the affiant, I'd say one, Yusef, the affiant in this matter, declares and affirms that on such and such and such and such date, I corresponded with such and such and such and such, requested that he provide a delegation of authority. I sent him in my correspondence, I outlined that his failure to do so would constitute a breach and would make him subject to penalties and damages in the amounts of blah, blah, blah that are outlined in my Exhibit A. On such and such, he was directed to send all correspondence to such and such address. He failed to do so. He did not provide me any information demonstrating his delegation of authority. Therefore, the only presumption that I can have is that such officer is masquerading as a public official and attempting to inveigle me into a contract or coerce me into a state of peonage, i.e. slavery, for debt collection, in violation of 18 U.S.C. 241 and 242. Number 2, I sent him a statement of account billing him for these amounts. He failed also to provide any indication, or attempt to pay these things. The amounts, this was all witnessed by a notary public, and give the notary's name. Make sure when your notary does your documents that notary has a notarial record book, and every time you go to that notary or something that you put your thumbprint in there, because then sometimes they do have the ability to ask the notary to show up in court and ask her to produce a notarial record book. Got a lot of people silent on the phone. Now, this commercial lien is intended to seize all the real and movable property of the above-cited lien debtors and those on the attached extended list of lien debtors. This property is being seized as a pledge to secure the above-cited obligation declared in paragraphs 2, 3, and 4 to apply it as a bond on the persons and activities of the officials, officers of the court, title insurance companies, and other such lien debtors. Now, that's another thing you want to do. You want to make sure you get, if they have bonds, you want those bonds. You want to attach those bonds too. And you want to notify whoever the holder of their bonds are that they have a insured individual that they're about to have to pay a claim on. And you list them. Now, I don't know. Now, here's something. These commercial liens, I believe, are rooted in natural law because, and I know it's international law because they can't do anything about it. The only way to get a lien off of you is they have to pay it, do a counter affidavit, they have to pay it, or they have to have a jury trial. And they won't usually try to go to court because they can't swear in with first-hand knowledge of anything, and they can't ever swear to a debt. That's why they avoid you at every turn. They won't sign affidavits. They won't give you any information. Here's some terminology that you could use. In the absence of a response, when the lien debtor was given an opportunity to respond, the lien claimant, and that would be your name, hereby inserts and records this claim of lien against lien debtor, jointly and severally, in the amount of $500 million. Said money is to be paid in coin minted by the United States Mint, 31 U.S.C. 5112 $. Said claim of lien is in the amount of criminal fines, penalties, and damages enumerated in a criminal complaint, which is going to be your affidavit of information, received by the United States Attorney and United States Magistrate, which total ledger amount is secured by the real personal community property of the lien debtor as follows. Personal, real, and movable property at, and then you make sure you have their address. Say that a lien debtor's wedding rings. This claim of lien is filed pursuant to, and then you have the code and the fundamental commercial law that existed nearly 2,000 years. And you can put all this in there. You know, you can come up with, when you start studying this stuff, you can be creative. The one thing about the UCC, what I like about it, it allows you to be creative. The whole reason that we have the UCC is because there is no money. Let me go back and make y'all understand something, why I'm even doing this today. There is no money. But everything that they're doing in the public is about debt collections. So what they're doing is they're trying to extract energy in the form of your labor from you, which is just a subtle way of saying that you are a slave. And they're trying to take this from you. You, on the other hand, if you remain honorable, they have a duty to honor your request, and they don't do that. When they don't do that, there are penalties for that. Usually, you can attempt to get this in court, and we find that the courts aren't doing anything. You petition the court for something, it gets kicked out. They don't recognize it. Judge recuses themselves. I had judges recuse. I've done administrative processes so good that when I presented it to the judge just recused himself because they don't want to answer it. So they usually find some kind of way of trying to circumvent doing whatever their job description tells them that they must do as an administrator and not give you the remedy that is going to be afforded to you, and then attempt to put you in some sort of slavery. And they don't have the authority to do that. So let me recap real quick. Whenever you receive it, let's say it's a child support issue. Let me use child support as how I would handle the child support. How I would handle the child support, I would always ask them, I always want to stay in honor. I'm going to be an honorable individual, and I'm going to request that they provide me with a payoff request. I'm going to write them. I'm not going to call them. I'm going to write them a letter, certified mail, return receipt requested, telling them that I would like the full amount that they claim I own in a true bill. Tell them it's in a true bill, statement of account. I'd wait for that. Then I would send them a negotiable instrument. Maybe you can use GSA forms from the General Service Administration, or you can draft an international bill of exchange or international promissory note or something to that effect. And I would send that to them. Once they got that, I would accept. I'd do a banker's acceptance on whatever the statement was, and I'd send them a negotiable instrument to them, directing them to close down the account and credit the account. You may even want to send it to the CFO. The Chief Financial Officer a lot of times understands how to do this stuff. When you send it to these low-level employees, a lot of times they don't know what the hell you're talking about. They just do what they're told to do. Do not send it to mindless minions who punch a clock. You can send it to them, but also make sure their superior gets something too, because they don't know what's going on. They don't know what's going on. You get that? All they're used to receiving is regular slave documentation. That's all they're used to receiving. on a regular basis. Now, once I get that from them, and what is that going in accordance with? That's going in accordance with UCC 3-311, which is an accord and satisfaction. Let me explain accord and satisfaction real quick to you, because I want you to understand this. This is UCC 3-311. I'm going to read this to you. What is an accord and satisfaction? Let me pull it up real quick. UCC 3-311, accord and satisfaction by use of instrument. Now, this is a very, very good thing to read, because it gives you some insight in what's going on in the game that they play with you. Now, when I read this, it says, if a person against whom a claim is asserted proves that a person in good faith is another word that you need to be familiar with, tendered an instrument to the claimant as full satisfaction of the claim, that the amount of the claim was unliquidated or subject to a bona fide dispute, and that the claimant obtained payment of the instrument, all of the following apply. Now, all of these claims are subject to a bona fide dispute because there is no money. A, unless Division B of the section applies, the claim is discharged if the person against whom the claim is asserted proves that the instrument or an accompanying written communication contained a conspicuous statement to the effect that the instrument was tendered as full satisfaction of the claim. That is why in your correspondence you're going to put in bold 16-point font that this, and you're going to take right here out of this, that this is for full satisfaction. Right here what it says, that the written communication contained a conspicuous statement to the effect that the instrument was tendered as full satisfaction of the claim. I'd put in there, this instrument is tendered for full satisfaction of the claim pursuant to UCC 3-311A. And you would use whatever your state code is for the UCC, because the UCC is codified in all 50 states. Find out what UCC 311 is, and right now I'm reading Ohio code, and it's Ohio code 1303.40. Now it goes on to say, subject to division of this section, a claim is not discharged under Division A of this section if either of the following applies. Now this is where they try to get you to slip up. If the claimant, if an organization proves both of the following, now if the state or these or whoever the child support people are can prove this, then your debt will not be discharged. A, within a reasonable time before the person against whom the claim is asserted tendered the instrument to the claimant sent a conspicuous statement to the person that communications concerning disputed debts, including an instrument tendered as full satisfaction of a debt, are to be sent to a designated person, office, or place. Now, this is how they get a lot of y'all. This is why we ask for the payoff, because on that payoff, it directs you to where you're going to send your payment to. That's why I said earlier you're going to send it to wherever it says on that instruction, and you're going to send it to the CFO. But you want to be in accordance with the rules of the Monopoly Board. So right here, when you get a payoff, it tells you who to send it to, where to send it, if you're going to dispute something, all of that. Now, when we go to B, it says the instrument or accompanying communication was not received by that designated person, office, or place. Now, if they can prove that you didn't send it or they didn't receive it, then the debt is not discharged. That is why we not only send it certified mail, but we also send an affidavit of mailing from a notary. Now, in your affidavit of mailing, you are going to give a complete description of the contents of your correspondence. This is also why I put the certified mail number at the top of my paper, and at the bottom and the foot, I put the title of the instrument, and I put the page numbers. Always, anytime you send a letter, you put page numbers at the bottom of your letter, like page 1 of 2, page 1 of 11. You always number it, because they will say they lost a page. So in that footer, you always put that, and you also put the title of the document in the footer and the page numbers as well. You can do that in Word by going to Insert and going to Page Numbers, and click down and click current position, and you will see that it will give you page numbers, new page X of Y, blah, blah, blah. Always put your page numbers at the bottom of your documents because they will try to lose your page numbers and say, well, we didn't have this. Also, in your affidavit of mailing, you are going to be sure that you put the page numbers in your affidavit of mailing also, how many page numbers were in your documents. The affidavit of mailing is nothing but a description of what they received. That is why you have to have that, because right here in B it says that they can prove that you can send them something certified mail, and they'll say, yeah, we got something certified mail, but wasn't nothing in the package. They will do this. This is why you have to have this. When you do everything right, you lock these people down. That goes on to say the claimant, whether or not an organization proves within 90 days after payment of the instrument, the claimant tendered repayment of the amount of the instrument to the person against whom the claim is asserted. Division B2 of this section does not apply as the claimant is an organization that's in a statement complying with Division B1. Now, that's saying if they can get you, that's the game they try to play on y'all. When you give them an instrument and then they still keep sending you a bill, this is why, because they're trying to see if you can be tricked into sending another payment. And that'll kill your first one. This is why when you send a negotiable instrument, they act like, oh, well, I don't know what you're talking about. Or they just ignore it and keep sending you bills. Well, that's why. Let's keep going. Uh-oh, I lost my, okay, there it is. Okay, now C, a claim is discharged if the person against whom the claim is asserted proves that within a reasonable time before collection of the instrument was initiated, the claimant or an agent of the claimant having direct responsibility with respect to the disputed obligation knew that the instrument was tendered in full satisfaction of the claim. Do y'all see that? That's saying that if you send something to someone and they know it's for discharge of the claim, then it's discharged. Now, what they will do is a discharge claim can always be brought back. This is what these third-party debt collectors are doing to y'all out there. What they are doing is they just send y'all a letter saying, yeah, we are ABC Debt Collection Agency. We bought this from American Express, and now we want you to send us $10,000. Or you can call us and make some type of agreement to send us $2,000, and we'll accept it. They are trying to inveigle you into recontracting with them and agreeing that there is a debt. Remember, there is no such thing as a debt. There's only a presumption of a debt. And if they can get somebody to act in any type of dishonorable fashion, then that debt becomes real. Y'all, they are playing games with y'all. But we have to learn enforcement techniques because especially when dealing with these properties, these people will come in and still trying to just take your property. It's commercial war. And you need to make sure that they pay for taking your property or taking your child or anything like that. There's going to be a penalty associated with that for kidnapping kids, for stealing homes, for trying to incarcerate someone. Now, we read in UCC 3-311. That is called an accord and satisfaction. Now, an accord and satisfaction is a legal term. You can find it and study it, accord and satisfaction, by going to the law library and getting an American jurisprudence or corpus juris secundae, and study accord and satisfaction. Because when you use these negotiable instruments, that is what you're doing. You're doing an accord and satisfaction. And the definition of an accord and satisfaction is an agreement to substitute for an existing debt some alternative form of discharging that debt coupled with the actual discharge of the debt by the substituted performance. The new agreement is called the accord, and the discharge is called the satisfaction. Now, Notice it's called an agreement. Now this gets back to Matthew 5:25, where it says, agree with your adversary while you're on the way to court with him. Now, you got to reach an agreement with your adversary. Agreement does not mean, and this is important, agreement does not mean that it has to be expressly written out. Let me read this for you. The term agreement, although frequently used as synonymous with the word contract, is really an expression of greater breadth of meaning and less technicality. Every contract is an agreement, but not every agreement is a contract. In its colloquial sense, the term agreement would include any arrangement between two or more persons intended to affect their relations, whether legal or otherwise, to each other. An accepted invitation to dinner, for example, would be an agreement in this sense, but would not be a contract. Now, what I want to show you is I want you to see that it's a contract, but when you go over to contract, and this is why we're putting everything in the form of a contract, okay, you want their consent. Now, when you read consent in Black's Law Dictionary, you'll see agreement. Approval or permission as to some act or purpose, especially given voluntarily by a competent person, legally effective assent. Now, when you look under consent, you're going to see a word called implied consent. Consent inferred from one's conduct rather from one's direct expression. So your conduct will give consent. This is also why you make sure when you draft your document, it is in the form of a contract, and you outline in there very clearly what you're going to do to them. If they do not respond, then they have consented to whatever the contents of that correspondence is. Now I'm going to give you all a good example of how they understand this. And I'm going to use Georgia as an example. Let me find it real quick because I want y'all to see this. Yeah, here it is. In Georgia, they have a code. And you may have to find this in your state. But this is a very important code. It's a very, very important code for you to know. It's under the evidence code. In Georgia, the evidence code is Title 24. Yeah, there it is. Okay. And OCGA 24423, y'all can Google this too if you want to, if y'all want to see this in Georgia. You're gonna have to find it in your state. I don't know all the state codes for every state, but what happens is these are principles, and they usually codify these principles into state law. Now it's called presumption for failure to answer a business letter. This is OCGA 24423, and it states, in the ordinary course of business, when good faith, remember I told y'all that word about good faith. When good faith requires an answer, it is the duty of the party receiving a letter from another to answer within a reasonable time. Otherwise, he is presumed to admit the propriety of the acts mentioned in the letter of his correspondent and adopt them. Now, the words I want y'all to look up in there is good faith, the word duty, the word presumed. This is right here in their statutory code. I use this code in Georgia for my notaries when I do my certificate of non-response. I have that code right there at the top. I have it right there at the top. Now, also what I want to give you, and this comes straight out of the American jurisprudence, the chapter on notary publics. I'm going to read this to you. It comes straight out of American jurisprudence, chapter with notary. It says a notary certificate is usually made prima facie evidence of the facts stated. And that's Fogarty versus Finally, Fogarty versus finally, Finally. Now it goes on to say, To impeach a notary certificate, the word impeach is a legal word. It means to make someone's testimony inadmissible. To impeach a notary certificate, the evidence must be clearly cogent and convincing beyond any reasonable controversy. When a notary certificate produced in evidence is contradicted by parole evidence, and the word parole means oral. Write that word down, P-A-R-O-L. That's why I got to get y'all vocabulary up. Is contradicted by parole evidence, the issue raised is one of fact for a jury. Now, let me read that to you again. To impeach a notary certificate, the evidence must be clearly cogent and convincing beyond any reasonable controversy. When a notary certificate produced in evidence is contradicted by parole evidence, the issue raised is one of fact for a jury. In other words, if they want to orally say that what you were doing is no good, then we need to go to a jury trial, because we already asked you to put it in writing. And that's Stewart versus Allison. And that's in Pennsylvania, actually, too. Stewart versus Allison, S-T-E-W-A-R-T versus Allison, A-L-L-I-S-O-N. But y'all can get all these cases out of an American jurisprudence. Now, let me read on. It says, a certificate of a notary public in due and legal form makes an instrument admissible in evidence without further proof of its due execution, and the burden is upon the person challenging the truth of its contents to prove his contention by clear and convincing evidence. So, that right there gives you the power of a notary on these notary certificates. This is why you want to have a notary present when you do this commercial lien process. Now, also, let me show you something else. I'm going to use Georgia as an example. Once again, you need to find in your own state how this is applicable. But we got something else. When we go to 24/7/23, this is in Georgia. I'm just giving y'all an example. OCGA 24/7/23. Is that right? Did I say 723? Yeah, 24/7/23. OCGA 24/7/23. Another real interesting, just to show y'all how these people know this stuff now and why they codify and everything. OCGA 24/7/23 is notarial acts proved by notary certificate. Now, you should have some sort of similar code in your respective state. What I usually do is I go into the law library and I'll do a search on my state codes, and I'll put a notary, and then I'll put certificate, I'll put comma, certificate, and then I'll put Pennsylvania code, and I'll see everything that comes up for notaries, and you have to read through it because you'll find jewels in there. That's how I found all this stuff. Nobody showed me this. I found all this stuff doing my own research in the law library, and you can do the same thing. All notarial acts of notary publics in relation to bills of exchange, drafts, and promissory notes required to be done by law may be proved by the certificate of such notary under his hand and seal, provided that such certificate is filed in the trial court at its first term and permitted to remain there until the trial. Now, the term in Georgia is when they set up the courts for jury trials, or they select juries and so forth. And that changes depending on the county that you're in and the population of that respective county. So you need to make sure you know what the terms of your court are, and you can file that into the court under a bill in equity, too. I would do that, too. I would do a bill in equity. You know, and why would I do a bill in equity? I do bills in equity cover my bases. When I get through doing an administrative process against somebody, I'm about to put a lien on them, I'll take it to the court. That's one thing I do. I'm not playing with you. I'll put it right in your face and let you know what I'm doing. And when you do a bill in equity, you are not you're asking for a judicial review of your administrative process, and you're asking that judge to sign off on what you did. You're not asking him to adjudicate anything. You're asking him to examine your paperwork, make sure you did everything properly, and then sign off on it. That's all you're doing. You're asking him to review your documents. And when you know these state codes like this is how you keep them in check, because they are required to follow that to the letter. Now, when you put these codes in there, that's what I do. Like I did let me see what I got right here. I did something, I filed it in court, and I put an affidavit of, and I put the notary's name, certificate of non-response pursuant to legal authority as codified in the Uniform Commercial Code, codified in the Official Code of Georgia, annotated OCGA 11-1202, OCGA 3505, OCGA 24-423, and OCGA 24-723. And this is what I wrote up for the notary. I said, affiant, and I have the notary's name, being duly sworn, deposes and states that I'm a notary who verified, and then I got the district attorney's name there, dishonor of, and then I have the individual who's being charged, notice of acceptance for case number, and then I have their case number, pursuant to state law regarding evidence of dishonor, pursuant to the Uniform Commercial Code, codified at, and then I have that. I am over 18. My mailing address is, and I have their mailing address, and I'm not a party in this matter, captioned above, and I make this affidavit in support of defendant. I certify the following. Now, you let them know that he's not a party, because they'll try to trick these notaries now. What they'll try to do is, a little technique that attorneys try to do is scare off notaries. So you got to have your notary educated and be able to stand. You got notaries out here in California, they scared to death, because they done changed a little law out here saying that they can only do protests for financial institutions, and nobody has taken the time to look up and see what the definition of a financial institution is here in California. So I got to sit here and spend all my damn time educating people who will not pick up a damn book and read. I called down to the Secretary of State, and I asked them. They said, "Nah, notaries can only do protests for financial institutions." I said, "Oh, really?" I said, "So what is your definition of financial institution, and from where do you derive such definition?" And they don't want to give you that. So let me give y'all financial institution, because y'all are financial institutions. Or you can, when you do your trust, you can have your trust defined as a financial institution, because you really want to do all this through a trust as well. Let me show you a definition of financial institutions. I'm going to put in, and this for all you people listening in California who's scared to death, you notaries. If you know a notary in California, contact them and tell them to grow a pair. I'm doing is being so damn scared all the time. But I'm going to give you a definition of, wait a minute, is this the one I want? No, this is not the one I want to use. The one I want to use is, I think it's in Title 31. Let me see if this is it. Title 31 is Money and Finance in the United States Code. Yeah, this is it right here. Okay, you want to go to 31 U.S.C. subsection 5312. 31 U.S.C. 5312. That's what you want to, that's what, because I want y'all to understand what a financial institution is. Because they don't want y'all to know what a financial institution is. And I'm having a hard time pasting this into my, let me see if I'm doing this correctly. 31 U.S.C. 5312. Let me read this to you. It says, and when you go to 5312, go to A2. Financial institution means an insured bank, a commercial bank or trust company, a private banker, which is what you are, an agency or branch of a foreign bank in the United States, any credit union, a thrift institution, a broker or dealer registered with the Securities and Exchange Commission, a broker or dealer in securities or commodities, an investment bank or investment company, a currency exchange, an issuer, redeemer, or cashier of traveler's checks, money orders, or similar instruments, an operator of a credit card system. So in other words, if you got a credit card machine, you are a financial institution. An insurance company, a dealer in precious metals, stones, or jewels, a pawnbroker, pawn shops, or financial institutions. A loan or finance company, a travel agency. A travel agency is a financial institution. A licensed sender of money or any other person who engages as a business in the transmission of funds, hell, that's in the grocery stores. Including any person who engages as a business in an informal money transfer system or any network of people who engage as a business in facilitating the transfer of money domestically or internationally outside of the conventional financial institution system. So if you operate, well, hell, that sounds like 2010 blessings. A telegraph company, a business engaged in vehicle sales, a dealership is a financial institution? Including automobile, airplane, and boat sales. Persons involved in real estate closing and settlements. That's a financial institution? Oh, look at this. The United States Postal Service is a bank or a financial institution. A casino, gambling casino or gaming establishment with an annual gaming revenue of more than $1,000. So all you people got, them little back office gaming things, y'all financial institutions. An agency of the United States government or of a state or local government carrying out a duty or power of a business described in this paragraph. Any business or agency which engages in any activity which the Secretary of the Treasury determines by regulation to be an activity which is similar to, related to, or a substitute for any activity in which a business described in this paragraph is authorized to do. Any other business designated by the Secretary whose cash transactions have a high degree of usefulness in criminal, tax, or regulatory matters. Y'all should read that. And you have monetary instruments, too. Now, another thing I'm going to give y'all, another jewel. Obligation of the United States. I'm giving away a lot of stuff today.
That's what you did it for, so you can give it away.
I know it, but I got to give it away before somebody try to stop me.
Yeah, it'll be too late.
I come and say, I got a lot of people got to know this. Now, I want you to go to 18 U.S.C. subsection 8, obligation or other security of the United States defined. Now, why am I doing all this? I'm doing all this because I want y'all to have some confidence when y'all write up these bills of exchange, promissory notes, these negotiable instruments, when y'all discharging these criminal cases, when you're discharging these child support cases, when you're discharging these traffic tickets, when you're discharging these mortgages, you need to have some confidence in what you're doing. Because there is no money. Rule number 1, there is no money. There's only the presumption of a debt and dishonor. Now, these Federal Reserve notes wait a minute, it's not the one I want. These Federal Reserve notes are obligations of the United States. Let me find this thing. 12 USC, because I want to show y'all where obligation of the United States is the same as money. When it's 18 USC, let me find it real quick. That's in Title 31. I think that's in Title 31. Let me see. Let me go back. Title 31. I think it's in Title 31, if I remember correctly. Yeah, I think this is 31. Yeah, let me see. Is this 3101? Let me see. I think this is it. Wow, this is interesting. I just came across this, but y'all might want to check out Title 31 USC 3101, public debt limit. They've raised it. You know, they're talking about redemption of a debt can't be more than it's $14 trillion. Title 31 USC 3101. That's the public debt limit. And let's see, is this payment of obligations? I'm going to have to find this later, but what it is it shows you 31 USC. I know I put that on one of my nations, same as money. Interest and penalties, money and finance, government printing, money and finance, prohibited obligations, interest, penalties. Let me take title, obligation of the United States. Chapter 17, currency and coin. Notice of fictitious obligations. And I found this actually going into...
Let me read this to you.
Go ahead.
18 U.S.C. subsection 8, obligation or other security of the United States defined.
Yeah.
The obligation or other security of the United States includes all bonds, certificates of indebtedness, national bank currency, Federal Reserve notes, Federal Reserve bank notes, coupons, United States notes, Treasury notes, gold certificates, silver certificates, fractional notes, certificates of deposit, bills, checks, or drafts for money, drawn by or upon authorized officers of the United States, stamps, and other representatives of value of whatever denomination issued under any act of Congress and canceled United States stamps.
What was that? It was Title 31 what?
18 U.S.C. subsection 8.
18 U.S.C. 8. I think that might be it. Obligation, United States obligations. Because the United States, Federal Reserve notes are evidence they're obligations of the United States. You know, they are not, you know, the government is supposed to be paying these bills, not us. Yeah, obligation of the security of the United States defined. I think this is it. Let's see. Yeah, I read that, but that's not the one I wanted. It tells you that all these can be considered as money. And Oh, this is good too. Vessel of the United States defined. The term vessel of the United States, as used in this title, means a vessel belonging in whole or in part to the United States or any citizen thereof or any corporation created by or under the laws of the United States. That is very important for y'all to understand too. 18 U.S.C. 9. That is your straw man. Put that up somewhere and keep it. Put that up somewhere and keep it, because that is talking about your straw man. Your straw man is a vessel of the United States.